You're in Palace Ballroom 3, and we're about to catch a talk by Robert Clark on legal aspects of full-spectrum computer network defense. So I'll pass the floor to Robert.
Thank you. Okay, good afternoon. Welcome back from lunch. We will try to keep you awake as best we can. The topic, legal aspects of active defense, or actually full computer network defense. On that, we're going to look at, I got to correct a couple things from last year, then we're going to basically look at how self-defense applies in the field as we go forward. My disclaimer, I am here in a personal capacity. I am not representing any government organizations whatsoever. I hope to be informative and slightly entertaining from that aspect, and actually I am on vacation. Errata, some things I need to correct and some differences from my pitch this year that are different from last year. Typically each year I have the $1 million giveaway. For the best comment, question, or heckle, I would normally give away a $5 chip, $10 chip, or a $25 chip. I really do apologize, but that has been canceled due to sequestration. And there's, so if I have to suffer, other people are made to suffer too on that aspect, so I do apologize. And, it was a little shady aspect, a lawyer trick anyways. It was only $5 or $25, and to get the $1 million, you actually had to go out to Caesars and parlay that into your own fortune on your own. I have an active defense scenario. I am a wanderer. I'll break into that for right now. My bosses hated that because when you talk to a court, you're supposed to stand at a podium, and I actually hate standing in one place. I have an active defense scenario that we're going to cover. Spoiler alert, if you do not want to know how that's going to come out, please turn away from the screen and don't look now. So I'm giving you a chance right now. Okay, spoiler alert. He's the bad guy. Now, if you're from my generation, actually, that's the bad guy. And you can get fine Corinthian leather in your Chrysler Cordoba. I got to throw out, my dad was from Chrysler. Okay, disclaimer aspects on life again. I'm here in a personal capacity. All my material is unclassified. Errata from last year. Last year, when I gave my background being from the Army Cert Legal Advisor to Army Cyber Command Advisor, not U.S. Cyber Command, I'm many levels down. I said, please don't write, an officer from, a U.S. Army Cyber Command lawyer said, because I'm in a personal capacity. Or I said, please don't write according to an officer from Army Cyber Command. I did say if you wanted to write something along the lines of, an officer from the U.S. Navy Cyber Command, go ahead and feel free to do so. That was inappropriate of me, and I would like to apologize to the Department of Navy. I never should have done that. It was irresponsible, and so therefore I wanted to correct that. So my background. I've accepted a position at the United States Naval Academy to join their faculty. So with that said, if I say something wrong that you don't like, please write according to an officer from the United States Army Cyber Command, and the chance that I say something that you like. Please write according to a distinguished professor of law and any other wonderful, lovely things that you want to write about the Naval Academy from that aspect of it. Last year, I also put some misinformation out there that I need to correct. I said it was a pleasure to be at the last Black Hat ever buying into the Mayan calendar. And that may have led people to also buy into it erroneously. And that was wrong, and I want to apologize. However, not everything on this slide is erroneous, because it was apparently the last year for Hostess, so the Mayans may have gotten it right as far as Hostess was concerned. Now, so I am not back next year. Yes, Hostess Twinkies have made a comeback. That's the only product I know that's making a comeback, but I don't want to have to correct this next year. I do have one public service announcement for you while you are here. Caesars Palace has banned the use of recording devices and Google Glasses. So if you are in the casino and you are recording things, you can end up going to jail. So as a public service announcement, please watch wearing the Google Glasses. But if you find yourself headed to jail, this is off the back of a bus here in Vegas. So if you want to take the number down, please do so. And given one other factor that I'm on Eastern Standard Time, and so I actually was getting up at 6:30 Eastern Standard Time, which is 3:30 here, and wandering through the casino. Some of the things I saw some of you folks doing, you may just want to jot this number down anyways. So, Cyber education. So my new position, this is very big. You know, there's a lot of articles written about actually working cybersecurity into our curriculums for both high school and colleges. And as such, that's exactly what the Naval Academy is doing with its Center for Cybersecurity Studies. I will point out, because being from my Army background, that West Point is likewise got a cyber center that they are standing up and moving on for this aspect. And so is Air Force, but I have no affiliation with them, so I don't have a slide for them on that aspect. So what the Naval Academy is doing is they've stood up a cyber operations major. All the midshipmen have to take 2 required classes as part of their core studies into cyber. And like I said, we have an actual cyber operations majors, and I'm pleased to be saying I'm joining them to add the non-technical content to their program, which is kind of neat because it's an aspect of having been in this background. If you're going to give cyber law and policy classes to a group of individuals, you know, it could be all over the place from this aspect. But having understand how DoD is using that technology, it's nice that I can mirror that up for them and bring it to the midshipmen for that aspect of it. They are trying to build themselves, and we are working very hard to say we are the go-to place for cyber. So media out there, I know when there's a counterterrorism thing, I see my former boss, Barry McCaffrey out of West Point, always in front of the TV screen. Hey, if you want to contact us if something cyber is going on there, please feel free to do so. When I go to conferences such as this, I'm hoping that when I see a presentation, I'm not learning a whole bunch of new stuff, because if it is, then I'm showing exactly how stupid I really am. I'm hoping that I've been in this business long enough now that, well, how should I say? Siri, open up a slide saying finding a golden nugget. Oh, so what's that? Okay, thanks. Not that golden nugget. Find another golden nugget, please. That's it. I'm looking for a golden nugget. What's the one thing to take away from a presentation that maybe you didn't know about before, that was a good resource, so it made your time worthwhile? I've been to a couple talks this morning, and like everybody else, I sit for the beginning, listen to it, catch the gist of it, and then head out. So this is your golden nugget. So after you see this one, if you want, hey, you can head out. Because there's actually 2 other talks that I wanted to see during my time here. So, the golden nugget. Active defense. The American Bar Association is going to be releasing a study on active defense. What is it? Harold Rishnikoff? I think it's Harold or Harry Rishnikoff, who's a very good friend of Stewart Baker, who is a very large advocate for doing active defense, is working on this report coming from the American Bar Association. So it's supposed to be top leading lawyers leaning forward and writing a document on active defense. So I point that out there. You can go to their website, the American Bar Association Cybersecurity Legal Task Force, and that should be coming down the road. So there's one of your golden nuggets as we move forward in our presentation here. U.S. laws and computer network operations. So whenever you ask the same question of 2 different attorneys, you're going to get 2 different answers from one aspect. I am not your lawyer. Please, if you have questions at any time, there's a microphone here to ask, or shout it out, and I'll be glad to repeat it. Especially when we get to the active defense scenario, you know, facts are king. And if you change the facts a little bit, your analysis is going to change a little bit. So please, by all means, ask questions at any time, and we'll get into them. Because one of the other aspects is, when you give me a scenario and you describe the fact pattern to me, that helps in terms of a legal analysis per se. Responsibility and the steak dinner. All lawyers are here to give legal advice. And you hope they give good legal advice. In private enterprises, you're paying for good legal advice. In the government, again, we want to give our commanders and our senior leaders good legal advice. But it's just that. It's legal advice. There are situations where the legal advice will be, okay, here's the law, black letter law, and by the way, if you do this, that violates the law. So, you know, and then I go home. And if you want to violate the law, you can violate the law. It's your choice. It's the leader's choice to do that. When you say this doesn't violate the law and it's a policy decision, again, that's the leader's choice. As I always used to tell my clients when I was a defense attorney too many years ago in Korea, here's the deal. You can plead out to this. Here's your sentence. I don't care. I'm going to go home and have a steak dinner. I don't know what they're serving in the confinement facility. So it's your choice. And that's the aspect. You're going to get legal advice, and your lawyers are going to go home and have a steak dinner. And it's your responsibility to listen to that legal advice, understand it, and make the decision. So we are not here as lawyers to make those decisions for you. We do not make those decisions for commanders. They make those decisions. Constitution, pretty damn good document, written back in 1787. Then there was a gap between the next thing that happened when we kind of acted on computer stuff. Don't know why. And oh yeah, there was that computer fraud and abuse thing that happened back there in 1986. So, how does the law apply to we the geeks from this aspect? Well, on a side note, Madison had great forethought when he wrote the Constitution. There is a little known footnote in the Article 2 powers for the president. And as such, if you'll know where to look, he dropped a footnote that said he envisions where Steve Jobs and other great inventors will come up with communication devices that will make Jefferson's dual quill pen look obsolete. So, accordingly, I think the president can do computer network operations on those things. I don't know what a computer is, but I'm sure it's going to be important. P.S., keep an eye on the IRS. So, with that said, you've got a couple of cases I want to talk about before we get into that. The courts have recognized that the computer security professionals are a special class. You get to get your prison sentence elevated because you are special people. And as I've talked about this case before, and many of you have probably seen, this was a case where Progner got arrested for carding, and while he had the right to remain silent, he did not have the ability, and gave a nice detailed confession, and the courts basically said, you use special skills, you're just like any pilot, lawyer, doctor, or anything, we're going to elevate your sentence. So it's nice to know that all you folks are recognized as being special in the court's eyes. Not really for a good reason, it's going to give you more jail time, but still, you are special. One of the other cases that's kind of interesting that I think you should know about that's going on right now is this case of In Re Innovatio, if I'm saying that right. Now, these patent owners are suing a bunch of coffee shops, hotels, over a patent claim, some say patent trolls, and that they're using and giving out free Wi-Fi in different places in violation of their patents. And they're doing the wonderful upstanding things. You think lawyers are bad. They're doing some wonderfully upstanding things where they're obviously contacting these coffee shops and hotels and saying, hey, for $7,000, $8,000, we will settle the claim and dismiss it and go away and not bother you. Well, one of the things they had to do is they filed the motion because they wanted to get the process for how they were grabbing the contents of the Wi-Fi sniffing. They wanted to file it in front of the court, which was a question of does it violate the Wiretap Act? So the court looked at this and basically said, data packets are being sent over an unencrypted wireless network, readily accessible to the public using basic equipment. The protocol used for the sniffing, again, is available to the general public. It falls under the exception of the wiretap statute, and so this evidence, with the proper foundation, is going to be admissible. So it was interesting to see this case. This is a civil patent dispute case. It's not a criminal case, but it is a civil case looking at Wi-Fi sniffing. So using a wonderful Riverbed Air PCAP NX packet capture, which is $700, Wireshark, a laptop, that this information is readily available. Anybody can do it as long as they're close enough to it, and therefore, in light of the ease of sniffing, that basically this is readily accessible to the general public, an exception to the wiretap statute, so go have at it. Now, when you get arrested, I don't know if you're going to be able to cite this case to DOJ, but have a good luck with that. One of the points they said is the public's lack of awareness that this can happen doesn't change anything. It is still readily accessible to the public. It's an interesting aspect because back in the day, there was a case called Kilo in which DEA came and used thermal imaging to look at a house and see, again, the grow lights going on in there. And they said, this is not technology that's readily available to the general public. This is an aspect now with the technology that's readily available to the general public and being able to use it, we're kind of moving down a path in a different area now. So, full spectrum computer network active defense. There is an important lesson to be learned as we go into this area. It's ironic, but it is spot on. And it's in Vegas. So, OJ and his bad legal advice put him in jail. And his bad legal advice said, at least up front, it goes, hey, if you can get back your property with no force from this aspect and no trespass, Go have at it. And of course, as we know from the facts of his case, there were guns, there was force from this aspect, and of course he ended up in jail, and I don't know, maybe should have called that phone number instead, but he is in jail. My last disclaimer, the wonderful aspect is I am not your lawyer on that aspect. When I pick a black hat topic, I'm always wondering, is this still relevant? Is it something that people are going to want to listen about? And the IP Commission report just came out a little while ago. Ironically, in this report, Justice Department was still quoted as saying, hey, this is illegal, you can't break the law. This report, which was written by Dennis Blair, the first Director of National Intelligence, and Huntsman, who used to be the ambassador to China, basically this report was looking at and saying, hey, look, getting your data back without harming any computers and networks is something we should be able to do. So it's an issue report, and of course, everybody's out there quoting this report now. Self-defense, protection of property goes back a long way. It is actually written into 21 state constitutions. It is based on your common law going way back in the days to be able to protect your property. And the aspect of this is you may use reasonable force to protect possessions. This Intel versus Hamadi case is very important. The law favors prevention over post-trespass recovery. And this is something this is going to be the main theme of what we talk about really today. What are we going to do ahead of time for prevention, vice jumping right to post-trespass recovery? So the active defense scenario I've got, we'll get into that recovery aspect of it, but there's several steps that I think you need to do if you're going to try to go down this path. Now, to use wonderful self-defense, there's all these factors here you have to do. The right to exclude one, from your personal property is not unlimited. You got to be in a place that you have a right to be, which is probably one of the key aspects on this aspect of it, that you have a place that you have a right to be. In Marcia's previous presentation, talking about the Computer Fraud and Abuse Act, when we were talking about unauthorized access or without authorization, and they say it's very vague. I can't argue with that. On that aspect, but if I'm your lawyer and I'm advising you, I'm going to tell you point blank, that's not too vague. You ask yourself on a policy aspect, do I have a right to be here? And that's a pretty simple question to answer when you go through the factors of it. And we'll dive into those in a little bit. So, again, right to protect property is not unlimited. Typically, deadly force is not allowed to defend personal property. And so, we're going to look at the aspects of building the aspect of reasonableness in a case. Now, Orin Kerr, K-E-R-R, so I don't know if it's Kerr, or Kerr, but Orin is a professor of law at George Washington University who wrote the cybercrime textbook that's being used by most people to do this. He works pro bono on a lot of cyber cases and aspects on life. And in his debate that he had with Stewart Baker on this thing online, he point blank said, I don't believe there's a digital right to self-defense. Now, personally, again, if I'm going to listen to a lawyer, I'm going to listen to him. So spoiler alert, that's how it's going to come out from that aspect. So when we're talking about this area, we're talking about building a case of reasonableness. The defense of property. So you've got to do things that are necessary and reasonable. So building the case of reasonable, those measures that you're going to do to secure and defend, obvious, technology, you're going to use informational intelligence, situational awareness, your policies, your information control, active defense. As part of active defense, there's that debate about deception going on out there, recovery operations, and stop the pain. What was missing from that slide up there? This is what we do in law school. It's the Socratic method. You ask a question, you guys got to answer it back. Previous and ongoing coordination with law enforcement agencies, which is what everybody hates. They ain't doing anything. They're not helping me. I got to do something. Well, you know something? You got to do previous and ongoing coordination with law enforcement. Why? Because the reality aspect of it is you're going to have to, if this goes south, attempt to convince DOJ or whatever prosecutorial office that's looking at you not to prosecute you. And there's a worst case scenario. Or you're going to try to convince a judge or jury that your actions were extremely reasonable and you're not guilty of a Computer Fraud and Abuse Act violation. Which, going back to what Orin said earlier, hey, I don't believe there is a digital self-defense. So it's kind of a nice little catch-22 in terms. Because why? Reality and practicality aspect of it is, DOJ is taking a hard stance with active defense. They are aware, and they've heard the rumblings, that there are offshore companies doing this. It ain't a secret. They are aware of that. And so they're looking at what's your requirement for self-defense or necessity to be used as a defense to a crime, committing a crime. Well, the requirement there is that there's no other lawful means available, i.e. law enforcement. So have you used all means and exhausted all remedies? Again, law enforcement or civil suits. So these are the things that you're faced with when DOJ is considering this. Because this manual on prosecuting computer crimes has been out for a long time. I can't remember how long because I've got a small hard drive. It's about the size of a first Apple computer. But it's worth about $360,000. And so doing so is illegal regardless of motive. So one of the other areas that we talk about when I talk to security professionals about this is how resource intensive this is. Who the hell are we talking about? I did government contract litigations for the Army, and you had a lot of mom and pop shops out there building small little pieces that fit into larger pieces, and if their company as a third party supplier is being hacked, they don't have the resources to do this. They're a mom and pop shop organization. So first off, you're talking about companies that have a vested interest in this and have the resources to do that. Now, talking to my experts in the security field, I say, hey, what do you think about this? And they say, they can't manage their real stuff, so how are they going to manage deceptive honeypots and things like that? They don't have the resource to do it. Be that as it may, but I see that this is going to be very resource intensive. So building the case of reasonableness, technology. Hey, there's no big secrets here. You're going to have all your aspects lined up there to build your case of reasonableness. You got your firewalls, intrusion detection systems, prevention systems, SSL proxies, you're logging things, monitoring these aspects. These are all things that you have to do building that case of reasonableness. And as part of honeypots and tokens, and as part of that, what's your authority to do that? Well, again, you've got the right, under exceptions to the Computer ECPA Wiretap Act, to collect this information, consent and service provider exception. So you're getting consent to be able to monitor your networks and do all this, which you're doing through your logon banners, your workplace policies, user agreements from that aspect. You also have the consent exception to, or the service provider exception to the wiretap statute, which basically says, as a necessary incident to protect your property, you can do this. A necessary incident is a little higher standard than preponderance of the evidence, and it's got to be tailored monitoring. The tailored monitoring obviously came back from the blue box cases back in the day when we were taking the whistles out of the Captain Crunch boxes to make free phone calls. When companies were recording, telephone companies, those conversations from that, they recorded the first part of it that identified the telephone number, half of it, and all of it. When the cases got to court, judge said, okay, you recorded when you identified the phone number here, those cases are good. You tailored that. Those can go forward for prosecutions. Where they recorded half of it, the judge would say, you knew the phone number up here, why'd you keep listening? And where the prosecution could argue why they did it, those cases continued going forward. Where they couldn't prove it or uphold their aspects, they were tossed out. And where they recorded the whole thing, typically those things were thrown out because they didn't tailor what was going on in there. So now when you're talking about computer network defense, it's very important to explain it to your lawyers. It's a three-way handshake. I don't know where that exploit's coming in. I'm setting up my sensors to capture everything. It's going to be out there on my sensors from that aspect. It's going to stay there for 4 hours and be overwritten. It might be there for 30 days and be overwritten, but it's going to be there. I'm going to get an alert, and then I'll go out and grab the data and look at it and do the analysis from that aspect. In my perspective, that's tailored and that's reasonable. But you got to explain all this technology to your lawyers. So I have this conversation, and it always strikes me as a lawyer, and I think, okay, maybe I'm getting this wrong because I'm just a stupid lawyer and I don't understand the aspects of it. But I was at another conference up in Maryland and ran into a couple techie guys, and I was asking the question. So if you got your intellectual property, your trade secrets, research and development information, the crown jewels of the organization, why aren't I air gapping that off, or at least doing encryption for my data at rest from this aspect of it? And they're like, I don't know. Oh, wait, I've heard it's too expensive, it's too hard to do, I hear a whole laundry list. No, they should do that. Oh, okay, well then I guess they should do it. So again, another step of reasonableness in terms of what you're doing to protect your data. So if you lose it and you go get it, again, you can say, look at all the steps I took to protect this data, and even with insider threat aspects, which is going to come up here, this is what I did to protect it. I'm taking reasonable steps to protect my property. I will say one thing about beacons. It's a controversial area. The ABA task force is supposed to be addressing this specifically because DOJ has opined out there that beacons can be put on by service providers. Most companies these days actually are service providers. They are providing email services to their employees, so they arguably qualify as service providers. But if you're not, you actually can't put a beacon out there. It's a violation of the pen, trap, and trace, according to DOJ. The ABA is supposed to be addressing this aspect. Next aspect that you should be doing, you should be pen testing and red teaming your network. One area I want to talk to you about is spear phishing. So there's this thing called the Lanham Act. And basically the Lanham Act is for your trademark registrations, and you're thinking, what the hell does this have to do with active defense? That's what I'd be thinking. Well, it's an area where lawyers sitting around over beers talk about this, go, hey, what about the Lanham Act? And you're going, what are you talking about? And I was like, well, if you do this, and you're like, and then we start talking about it. So it protects federally registered marks against consumer confusion or dilution. So it's that aspect of lowering the public's perception to trademarks. So you have this great idea. You're going to send a spear phishing to your employees using a trademark, Beyonce tickets, $45, front row, backstage passes, or hey, the upcoming football game, NFL Network, all these. You're going to send this to your employees. And you know what's going to happen? Your employees are going to forward that to their 15 best friends who are going to forward it to their 15 best friends. And before you know it, you're getting a knock on the door from someone saying, what the hell are you doing? This is bogus, it's not responsible, and you're in trouble. Now, I'm not a Lanham Act attorney. And before you blast me on the eval saying, well, why were you standing up there talking about it? Because you have to go hire the law firm of Dewey, Cheatham, and Howe. And in that law firm of Dewey, Cheatham, and Howe, you're going to have several branches. So when you get this idea to go do this, you're going to have to go to your Lanham Act branch and say, here's what I want to do for spear phishing. You need to get your attorneys involved early and often so you can talk through it and say, here's what I'm planning on doing. And they can say, are you using an actual trademark? Well, yeah, we were going to send Bank of America kind of, we need, you check your, and what is the information going to get back? Are you going to get their account information back? Are you going to get their social security number? Yeah, we're going to have them fill in their social security number. You're getting their social security number? Well, when it comes back to us, we're going to set it up that's just gibberish, but we need to set up in a field that's going down that path. All right, great. How are you controlling this? If it's back to my Beyonce tickets, can they forward it outside of our network? Oh, yeah, we didn't think about that. Oh, yeah, that's a problem, because they tell you, it's happened. And it was a wonderful aspect when people are getting calls and senior leadership saying, what the hell are you doing? Putting this out there, and it's a nice mess. So these are things you need to think about as you're doing these things. Intelligence and situational awareness. The big thing that we always say, you can't defend your network, A, if you don't know what your network is, and you don't know the situational awareness of what's going on. So you're going to use your open source intelligence aspect. You'll get your bulletins from the US CERT. You're going to contract with a commercial intelligence provider, one of the ones out there, iSight, iDefense, the whole groups out there, to get information on what's going on. And you're going to do active business intelligence. That's permissible to do. And you're looking at what is that competitive intelligence versus economic espionage. So economic espionage, you're thinking, whoa, wait a second, what the hell are you talking about? Well, we know what economic espionage is. We're protecting trade secrets from this aspect, with a systematic approach, because in this high information technology age, we need to have a situation to do this. So there's two areas from this aspect, and it's kind of the main thing. Am I getting information or trade secrets without authorization or knowing that these are trade secrets? So with that Economic Espionage Act, good old Doug and Kristen here wrote a nice little article about it. It's in the presentation material aspects of it. But they were looking at basically the Economic Espionage Act. And it's a broad, it applies more broadly than most people think. And the fact that it can be a struggle for companies to handle this, and that some lawful methods in which you get things might in fact constitute a misappropriation. Now it's funny, in the military, this is the aspect where you say aggregated material. I can have a bunch of unclassified material, but when I put it together, it gets an aggregated aspect of a classification. It's the same thing here. If I grab a whole bunch of stuff that out there is open source, publicly available, and I aggregate it together, they're saying here that may be a problem. In terms of combinations of it. Now, that's back in what Doug and Kristen are saying. I will say this, that under this particular case here, possession of open source material is not economic espionage. So there's case law out there as far as the criminal prosecution aspect of it, but our buddies Doug and Kristen say be careful when you're doing it. As such, William also wrote some aspects of it. When you're doing this again, looking at open source material, that it's ethical and lawful to do for what, as you're out there. So what are we talking about? Well, you're talking about research plans, R&D, stuff that's out there, product designs, things that you're going to get there, pretty much publicly available aspects on it. Your methods, typical data mining, and it's funny because I was over at the DDoS attack next door, and they're talking about use of social media, LinkedIn, and this guy's Facebook page. We're actually kind of linked to his criminal activity, which is kind of, I guess if you're advertising that, that's how you do it. Patent tracking, psychological modeling of rival executives. That's kind of neat. My wife wants me to get some psychological modeling on that. So this is the things, conversations with rivals, customers, partners, and employees. So it doesn't mean that that's misappropriation aspect, again, because you're focused on publicly available information. Areas that raise ethical questions that he talked about, William was talking about, appropriating documents misplaced by rivals. And I'm kind of like, like an iPhone lying around at a bar. I'm like, that's kind of interesting. Now again, when they're misplaced, again, go back to the statutory definition of this. Trade secrets and receiving them knowing that they are trade secrets. So there's an argument made, misplaced documents just left behind, abandoned. Okay, one aspect. A couple years ago, I think the Coke recipe made it into Pepsi's hands, and they just shipped it right back to them. Because that's not misplaced. But, an interesting aspect. Overhearing, and William talks about overhearing rival executives discussing strategy. I'm sorry, in my aspect, that's misplaced trust in third-party doctrine. If I'm a place where I have a right to be, and, so Batten, Barton, Durston, and Osborne, an advertising company, always has beers at X bar, and I know that, so I wander in there and sit at the table right next to them so I can purposely listen to their conversations. Hey, again, I'm in a place I have a right to be, open space, publicly available. Hey, misplaced trust, third-party doctrine. Yeah, again, these raise ethical questions. He's not saying these are exactly illegal. Hiring employees away from rivals. Hey, great stuff with the Computer Fraud and Abuse Act, so you also get in with that there. And dumpster diving, which, one of the great things that we always love. Which there are cases out there that once you place your trash out by the curb, it is no longer within your possession and it's open season, I guess. But that's what Bill Bradford is talking about when he's looking at these areas. Methods that clearly are crossing the line, which is kind of important for you all, electronic eavesdropping, surveillance, social engineering, bribing aspects from that aspect. Now, I again am not an EEA lawyer. You're going to go back, and before you blast me, to your law firm of Dewey, Cheatham, and Howe. You're going to go over to the EEA branch, and you're going to talk to them about what you're going to do. So that's another aspect that's very important. Interesting aspect of outright stealing trade secrets. So in United States versus Lenikov, Sergey worked for Goldman Sachs, and he was responsible for one of their high technology products there for trading. Using that statistical algorithm and proprietary information. He made $400K. He was the highest paid programmer of his 25 group, and he was hired at a competitor for $1 million. We in the legal community like reading facts because it can kind of tell us where we're going, from this aspect. So kind of where are we going on this case? His last day of employment. Where do you think we're going? Just before his going away party. It gets better. These are great facts. He loads 500,000 lines of code out to Germany. Then he deletes the encryption program and the history of his computer commands, and later downloads it to himself and takes it to a Goldman Sachs competitor. And believe it or not, he was convicted of stealing and transferring computer source code. He appealed. And it was overturned because the source code was not intended to be placed in interstate foreign commerce, so he was not guilty of the Espionage Economic Act. Now, before you all think, wow, that's cool, what a great way to make money. Yeah, the act was amended very shortly soon after to kind of grab this one and take care of it. So kind of an interesting little aspect of good old Sergey. Next step of reasonableness that you're going to build and you're going to do. All right, your policies and your training. Now, the big aspect on this is the enforcement of those policies and training. And this is very big for computer fraud, abuse, and insider theft aspects on it. because if you're not enforcing the policies or they're inconsistent, they can cause problems. So you're going to have your information assurance training, have your banners up there, the user agreements, acceptable use policies, do your annual, semi-annual, quarterly training and the enforcement of these things so that, you've got this. And are you disciplining your employees when they violate these things? Again, building that case of reasonableness so if something heads south, you can stand up and say, here's everything that I did. Information control. Again, this is the aspect I always get the techies, and I'll be honest, even myself, when we implement something new, it always takes things longer to boot up from that aspect. Everyone gets mad. But, are you putting access lists and your encryption on there in terms of data at rest? Are you encrypting that? Digital rights management, what are you doing to control the documents that are actually being made? How far can they be forwarded? Who gets access to them as far as your access list? And electronic mail control, what are you doing that? If I write an email, can it be forwarded all over hell and high water, in which case I'm going to see it in the Washington Post? What are those things that you're doing that are reasonable to control your information? So active defense and deception. Again, you get a group of lawyers sitting around having beers and you start talking about different things and you wonder, who the hell's bringing up the SEC? What do I care about the Securities and Exchange Commission? Well, there's a duty under the Securities and Exchange Commissions for public disclosure of information for a company to the general public aspects in life. And thanks to Reed Hastings of Netflix fame, the SEC said, hey, something? We can investigate security violations or potential security violations pretty much whenever we want. So if we think something fuzzy's going on there, we might just come and investigate it. So again, back to my aspects of I'm not an SEC lawyer, so when you're going to blast me on the evals, but when you go to Dewey, Cheatham, and Howe, and you're going to go over to your Securities and Exchange branch, say, what the hell do I need to know if I'm going to go down this area? Because there are regulations for the distribution of information that's going to go out there that's available to the general public. And as part of that, what is the aspect of if I have deception going on my documents? What if I've got documents on my internal system that I specifically put there as a deception plan on my internal documents with no intent of being made public whatsoever, and they're stolen? That's why I set it up. I want them to steal my deception plans. Those are the documents I want them to take. I don't want them taking my real stuff. So, what happens? Those documents are leaked to the media. They're on my letterhead. They look legit, because otherwise, if they don't look at the bottom, a footnote, hey, congratulations, you stole my documents, these are fake. It's the aspect of you want them to take these supposedly legitimate documents. Is that a public disclosure? Now, as a lawyer, if you come to my general counsel and you go to your general counsel's office, they're going to say, we didn't affirmatively take it over. It was stolen, from that aspect of it. But is that going to stop an SEC violation or investigation? I don't know. Tell me how that works out for you. Because if I'm the SEC and I see these documents coming out there, I'm telling you, I'm going to be knocking on your door. Your shareholders are going to probably want me knocking on the door as you're sitting there trying to do a public campaign to explain, this was just a deception plan, which now blows the fact that you have a deception plan. So, it's an interesting aspect and an interesting dilemma. That's why you got to get your securities and exchange lawyers involved to have this when you're having this discussion for what you want to do. So, examples of what you're going to do for a deception plan. You can have requests for proposals in there as part of a deception plan. Fake ones that, you're saying someone's doing a request for your third-party supplier, and these are some requests for proposals I've got from other companies. Or I'm putting out, I actually put out requests for proposals, so I've got fake ones in there for my deception plan. I love this. Bid preparations. I took a course at the University of Michigan on engineering and construction law, and my professor actually gave us an example of how to put a bid together. And he passed out the sheets, given 30 students, and he hit the stopwatch. He goes, you got 5 minutes to do this. Everyone's running all over. We got calculators adding stuff together. The bids that we put together were in a range from $5,000 to $5 million. And he goes, I hate to tell you this, but this is exactly the way bid preparations are put together. Because you are trying to get the lowest cost you can from several different suppliers, and they're always coming in and you're updating them at the last minute. So when you got your fake bid preparation on that, this is the one area where I'm like, I'm not sure anyone could ever argue that these are actually fake because they're all over the place. Blueprints and designs. Defending your property is not unlimited. You cannot cause physical harm or death, arguably, unless it's reasonable and there's a huge threat there. But typically, you got to refrain from physical harm and death. Minor defects to your blueprints and your designs. So if you're a soda company and you make it taste crappy when they sit there and they try it, okay, big deal. I always love the aspect of, my dad worked for Chrysler, so I'm like, okay, so what if I, do a little design here where when the door handle opens up here, it gives somebody a battery, a huge electric shock, from that aspect, and I actually am harming people or something like that. So the question is, if you're going to have fake blueprints or designs, what kind of defects can you put on that? What are you going to put on that? Business plans and financial records, say hello to the SECs if those end up becoming public on that aspect. And the other aspect is mergers and acquisitions. Again, you get a bunch of lawyers kicking around, we start thinking about these things. So what's your liability to third parties? Because if you're going to do deception documents, you got to make them look realistic. So you got to name actual people that you want to merger or get together with. And if they're in your documents and they get stolen and they get leaked and those companies are harmed, yellow, lawsuit, here we come. I mean, if I'm that company, that's what I'm going to file a lawsuit like that. Say you are negligent and irresponsible in putting that document there or protecting it. All right, so again, these are all the wonderful aspects of doing a deception plan that you have to be worried about. Thinking break. Oh, joke. Funny. You guys. Okay, so there's an SQL query, walks into a bar, sees two tables, says, hey, can I join you? Again, I said I need that psychological profile. I need therapy. By the way, I thought that was a damn funny joke, which actually shows you how warped I am. All right, the active defense aspect of life. Everybody wake up. This is the part you've been waiting for. It's an interesting aspect of putting this up here I love the new Star Trek. They're doing a good job. The Kobayashi Maru. Because I'll tell you something right now. When you're talking about recovery operations, I really do believe this is a no-win situation. The fact pattern we'll go through here, please shout out questions, fact patterns, changing things as we go through this, because you change a couple of the facts here, it changes what you could possibly do. But I agree with Orin Kerr. I do think this is a no-win situation. Don't blame DOJ. Don't blame DOJ for anything. Blame Congress. If you got a problem with something, you need to talk to Congress about changing the law. Okay? You elected them, they work for you, that's what needs to be changed. DOJ is just there doing their job. Yes, they have prosecutorial discretion from that aspect on life, but again, they are there to prosecute the law. You need to talk to DOJ about changing the law from that aspect. So, active defense. All right, Clark's Law. I'm trying to get famous for this, kind of working a little bit. Clark's Law is simple. Get your lawyers involved early and often, and explain the technology to them at a third grade level so we can understand it, but we can turn to senior leaders or judge or jury and explain it at a first grade level. Get your lawyers involved early and often and explain it to us in great detail. We want to listen. We have hopefully that analytical training to keep asking questions to understand it. And that's what we want to do. Now, simple is best for us. So my scenario here, I'm not a PowerPoint guru. I know I'm in the Army and we have PowerPoint badges and all that stuff. I'm going to the Navy. But the aspect on this is I've got very simple PowerPoint slides for this. There's my intruder. And there's my innocent third party. And he compromises the third party, heads over to the victim machine. He's going to exfil some data over to an FTP server, and then he's going to go grab that data from another hop-off point and exfil it to that box over there. Again, it's pretty simple, but my experience, that's typically how we've seen things from this aspect on it. What can I do? So, I've got an innocent third party, and I've got logging stuff that I'm doing. Can I look at those logs? Yeah, that's a pretty stupid question. Of course you can. I've got logging capabilities, so I'm going to look at the innocent third party coming in, touching my box. Have I seen this IP before? Is there a history of it from that aspect? So I'm going to see the innocent third party there. Am I going to see logging of the FTP server? Yeah, I'm going to catch. I see the exfil of data going out from this aspect, and so I'm going to see it going that way. I'm going to jump ahead of slide as far as exigent circumstances that I always hear. I'm seeing my data go out, and I've got to go after it. All right, most of the experience that I see is when my data's going out, it's encrypted, so I have no frickin' clue what's going off my system. So to sit there and say, this is my research and development crown jewels, it's kind of debatable a little bit, aspects of life, but, so that's why I have a problem with the exigent circumstances. I gotta run after it. But, be that as it may, I do see the logs going out to the FTP server from that aspect, from my system. Wow, hey, the garden pool party is gonna start at 7 o'clock. Let's see. Logs, come on. Oh, because I got a message, it's now thinking. All right, now I can't wander. Close. So, logs, the third-party intruder. Am I going to see those? Well, not on my box, I'm not, for this aspect of it. Are there going to be logs on an FTP server that's going to see that aspect, that connection there? Yeah, there are. When I go to that FTP server, if I have a right to be there, am I going to see that? Typically not. So actually, if I jump on that FTP server and I elevate my privileges, again, if you were here for Marcia's talk, elevate my privileges, count 1 of Computer Fraud and Abuse Act in terms of finding the logs and looking at the logs from that aspect. So that's kind of an interesting aspect from that, looking at the intruder's box. So those are your log aspects that you're going here. Deleting data, my property, recovering my property, things that people want to do. Can I delete the data off the FTP server? Who thinks yes? Good. I got one person here thinks they can do it. That's great. If this is an open FTP server, anonymous, anybody can log into it. Can I delete that data off of there? Who says yes? See, I got a couple more hands going up. All right, now I asked you a question, because you're the techies, I'm not. On an open, anonymous FTP server, is it typical that it's set up so I can upload files, download files, and delete any file that's on there? Is that the way it's typically set up? Yes or no? No? Okay, so I'm going with what you guys are saying. No, typically it's not. I can upload files, I can download files, but it's not typically set up for me to delete files. So now it's an aspect. If it's an open FTP server, anybody in the world can get on it. So I can get on it. I am a place, I'm in a place I have a right to be. I can get on it. My files are on there. Can I delete them? Well, it's not a function that's available normally for a system, but they're my files. And if I use reasonable and minimal force, I delete them without harming that server whatsoever. I'm at a situation where I'm going to have you call your law firm of Dewey, Cheatham, and Howe and ask them. I don't know the answer to that. So from that aspect of it, now, if I'm your lawyer, yeah, I'm probably going to say go ahead and delete them. You're not harming the server from that aspect of life, if I'm your lawyer. But here's going back to that steak dinner thing. Now, I'm going to tell you, DOJ may think that's a violation of the Computer Fraud and Abuse Act because you just deleted information off of a system you don't have the authority to do, because it's not set up for anybody to do that. So it's an interesting aspect, wonderful debate, but it's my property. Can I delete data off the intruder system? Question? All right. So can I delete data off the intruder system? Hey, this is an easier one from that aspect. Do I have authority to be on that box? No. That makes it a protected computer, unfortunately, from that aspect. So I can't get on that box. So if I get the logs from the FTP and I find a way onto that box, count 1, Computer Fraud and Abuse Act. Now I'm on that box, and I'm just going to take my data off of there and delete it. Haven't caused any damage whatsoever, but I've exceeded my authority on that box. Yeah, it's probably going to be tied into the first count of actually accessing the box from that aspect, but that's the problem with looking at my property being on that intruder's box. So again, if you're going to do that, call your law firm at Dewey, Cheatham, and Howe and tell me how that works out. Change that to an innocent third party up there. So now you're looking at logs aspect. That open FTP, I still think you got to elevate your privileges to see the logs of that innocent third party. But if you get them, from that aspect, now you know who the innocent third party is. So, you've got the logs from that. So, and now, can you get the logs from the intruder logging into that innocent third party? Well, if you get consent from that innocent third party, sure. You can go up, hey, call them up, say, hey, can I see your logs? I lost some data. It came from an FTP server. Can I check out your logs? Consent's always a great way to get it from that aspect. But if you jump on that innocent third parties and you're monitoring their systems and getting their logs, not so much. So deleting data, same argument on the open FTP. If it's an open FTP, that hasn't changed anything from that. Can I delete the data off the innocent third party? They don't even know it's there. When I talk to my techies, I go, look, they've got a massive system. They got stuff all over the place. By the way, they got stuff from our competitor on there too. Should we grab that? No, probably not. So it's an aspect of they don't know that it's there. We just want to delete it. Hey, again, that innocent third party, I'm going to say, call them up and get consent. That's the aspect that I would say from that aspect. And see if you can delete it from that aspect. Can I delete it now that I find out that I went over to that intruder? I'm back to the aspect of protected computer. I can't touch that box. Computer Fraud and Abuse Act from that, so I can't hit that one. My favorite one is when I get to the FTP server and it's not an open server. But my logs or some other aspect, I've got the information for how to log on to that box. I got the username and I got the password, so I can actually log on to that FTP server. Can I do it? Yes or no? I hear a lot of no's. That's the conservative answer from that aspect, from that. Now, I would argue a third-party exposure, which is what, basically we are arguing and have been arguing for a long time, dealing with all the NSA programs of Smith versus Maryland. When they gave that information, that telephone number to a third party, there's no expectation of privacy, there's no rights in it. So when they expose that, when they download the information to the FTP server and my logs capture that information, you've exposed it to me. Why can't I use it? Now, that's the argument I'd make. That's not the conservative approach of I'm not in a place that I have a right to be. Because the aspect of this is, say my neighbor has a cipher lock on their door. I know this because my kid's taking care of a neighbor's cat and they had a cipher lock on the door. And I had to go over there and press the thing. So my neighbor borrows my baseball mitt. And it's in their house. And I know it's in their house. And I know their cipher code because my kid was taking care of their cat. Can I go over there when they're not home, use the cipher lock, open the door, and go in and get my baseball mitt? I don't have authority to do that, even though I know that that's what the cipher lock is there. So that analogy aspect is an interesting aspect when you're dealing with that closed FTP server from that. So basically when you're dealing with these areas, clearly as we're talking about, you're going to have good computer network exploitation, good G2, good information in terms of all that information, what you're getting. And again, we talked about that exigent circumstances argument where people say, but I saw them go to my research and development section. Now, if I saw them go to my R&D section and the data's encrypted and I know my crown jewels are there, okay, yeah, I got an exigent circumstance there. But if they've gone to my HR department and they've just stole my personal information from my employees, well, I'll notify my employees and say, hey, sorry about that. But at least the business isn't going broke on that aspect. So, I got 10 minutes left. If you have questions, sir. Does geography play a role? That's a great question from an aspect. So most countries have computer fraud and abuse type statutes from that aspect and computer crime aspects on life. So, from that aspect, and even in the United States, they can, if you go hack into a computer in England, from that aspect, they consider that a protected computer. So you could face, either in the site of the crime that you committed it here from the United States and the hack back, or you could be facing it with another country. It's an interesting aspect. The recent articles that are coming out about this against doing this is a lot of people saying, we don't want this vigilantism going on there because someone could hack back to China and it could tick them off and we could start a cyber war. Okay, I'm hoping when you hack back and get your data back that you do it really discreetly and you're not doing it as noisily as maybe something else, but that's beside the point from that aspect. But geography definitely comes into play from this aspect. Other questions? All right, so the stop the pain aspect, the big one everyone always wants to look at, and they want to talk about the, the denial of service aspects. This is very fact specific, and so I'd love to be able to get into something like this in this forum, but it's where I'd actually have to sit down and talk with y'all to find out how you're going to get back to that C2 server. I think the classic examples of this is what DOJ has done in the Core Flood botnet takedown and the other botnet takedowns that they've done. There's some great documents out there. Now, I will point out one interesting aspect talking to DOJ on this aspect. When they've gone back and set up their, taken and set up the new C2 server to basically render these botnets ineffective, they have gone to great pains in these documents, the temporary restraining orders, to say we are not transmitting any code whatsoever to clean up people's computers. They won't touch your boxes and clean them up. Now, TDL4, when I get my virus all hacked up by that thing, will clean my machine and get other malicious malware off of it because it doesn't want to trip off any alarms or anything. So actually, malware is better than DOJ because they'll clean my box for me at least as it's sitting on my box. But DOJ says we're not going to touch anybody's box. So I do point that out from an aspect of how they're going about doing this from that part of it. Again, back to the commission's report, they do talk about meta-tagging, watermarking, and those things. I love the aspect they talk about photographing the hacker. There was a warrant that was just denied because they didn't know who the hacker was and they wanted to turn on the camera for that aspect, and it was denied by a judge. So it was an interesting aspect. So the golden nugget, last one, taking away from this aspect of it, if you're going to do this, you're going to need a great team from that law firm of Dewey, Cheatham, and Howe that has several different, and by the way, these are just a couple brainstorming branches that are out there from this aspect, because you're also going to need the IT law and your criminal lawyers over there to do this. So if you're going to do this, you're going to need a great team of lawyers. Or if you're really going to do this, get one really great lawyer to handle this for you, from that aspect. If you have any questions, I will be around. I will be up here. I thank you for your time and your attendance, and that's the aspect of doing a reasonable defense for active defense.